So yeah, Mike and I were visiting the other day, and he had a couple questions come up, and I've had several, and there's some people on this call I know that I've talked to about this topic, and so we thought, why don't we just try to put together a short kind of a lunch and learn program over a webinar, and just give the opportunity to kind of talk about our thoughts on this, and get feedback from you guys as well, and answer questions, and kind of collectively share our knowledge on it as we approach the upcoming implementation date for the first increase to the threshold. So we'll just kind of go through some basics first. Probably be fundamental to a lot of you. Maybe some of you may pick up something new in that, and just kind of talk about what's happened, and then talk about what, from Mike and I's point of view, what a HR professional or other person that has a payroll function as part of their job, what they should be thinking about with their exempt staff as the July 1 deadline approaches onto us. So Jasmine, let's just go ahead and advance and jump into the kind of the first screen.
Yeah, and y'all hit us up with questions or comments, because I got to tell you, just in the last 48 hours, I've had discussions with 3 or 4 different clients that have brought some kind of interesting little twists to compliance that it all, as y'all always know, if y'all ask questions or make comments, we get interactive, and that way we all learn a little bit more.
So yeah, you use the Q&A for now. If our chat's still disabled, we're monitoring the Q&A as we go, and we'll jump over there and answer anything that comes up. First slide here is just and I see Tara's, as she is good to do, starts the ball rolling, and we'll definitely address that. And the first slides here is a great place to do it. So this is just kind of a breakdown of the where we are currently for the salary threshold for the white collar exemptions. When I say white collar exemptions, I'm primarily referring to supervisors / executives, administrators, and professional employees. And then there's also a corresponding amount with scheduled increases for highly compensated employees. And so you see those amounts on your screen. I like to think of it too, as a weekly amount. For years, Mike and I were discussing that, around 2004, the amount went to $455 a week. And it stayed, that for a period of time, and until we get to the current amount we have now, which is about $685, $684. That's what I was thinking. So, these do have to be paid on a quote unquote salary basis. That's its own kind of legal term of art. The one exception is if there is we'll talk about a few slides later that relate to bonuses and commissions. So yeah, that's, like I said, that's we haven't had an increase of this magnitude in a while. There was an attempt in the Obama administration, I believe, to raise the thresholds by a significant amount that didn't survive a court challenge. And so there has been a court challenge filed to these. We'll discuss more in later slides. But yeah, Mike, any general comments on where we are now versus where we're scheduled to go, and court, any preliminary thoughts?
Yeah, the historically when I started, the rate was really, really, really low, and it was that way until the 455 and 04. And then you remember in 16 and 17 there was the effort to increase it to what was 913 a week, which was a huge increase. And I can remember spending hours and hours with people trying to figure out how to reclassify. And then of course the court took it down, and then we got into 2020 where we got to the current, and let's just talk about it because of some of the nuances. I think it's easier to talk about it on an annual basis than a weekly basis.
Yeah.
and then and so then the new amounts for the highly compensated employee are just uh, uh, really significant increases. And the kind of the interesting thing, y'all, is that, and it's for all wage hour law now, is that the regional differences in pay, uh, these changes don't mean anything to any of my friends in San Francisco. There's nobody that would meet the duties test in San Francisco that's getting paid less than 58 grand. So they don't care about this. And I was at a conference of employment lawyers from all over the country and Canada a month and a half ago, and most of them weren't talking about this because it doesn't affect them like it does us, because they're in large parts of the country that the pay rates are high enough that these changes just don't matter.
That's right. To kind of, well, and another questions come in, but I'll address Tara's question first of what we, a part-time exempt employee. There's no distinction between part-time, full-time with respect to the exemptions. So you either meet the qualifications for the exemption or the criteria for the exemption, which includes the salary threshold, or you don't, regardless of if you're a full-time or a part-time employee. So, if you currently have a part-time exempt employee, they have to be making $35,000 or more on a salary basis for a year. If they're not doing that, they're not really exempt. And so that's, and so but if they're a part-time employee, it's somewhat of an academic point because they're probably not working any overtime. So the only wrinkle to that for compliance would be, are you record keeping? Are you keeping records of their time as a non-exempt employee, whether they're part-time, full-time, et cetera? There would be a record keeping requirement that you record all their hours worked. And then, you would just a verified document that as a part-time employee, they're not working any overtime. Because again, the primary point of kind of all of this is exempt. What are they exempt from? They're exempt primarily from overtime. We're not as much worried about minimum wage in Arkansas with an $11 minimum wage. Are they exempt from overtime? And so if they're part-time, not working the overtime, it's somewhat academic, other than you do have a record keeping requirement. So that's on that one. The other question related to the amounts for HCEs, including bonuses and commissions. It's a great question. Well, I think we're about to get to it here in the next slide or two. So stay tuned for that on the bonus commissions question for the HCE salary threshold. So yeah, anything else on that, Mike, before we advance? I feel like that kind
I
of
think
covers
it's time. Yeah, let's move to the next slide. And y'all keep putting your questions in the Q&A for now. Are teachers exempt from this regulation? No. Teachers are still, they're a little bit different in a professional capacity. But the rules are going to be the same.
That's right. But so like there's no new salary basis requirement where there wasn't one before. So to the second bullet point in the slide there are certain exemptions that don't have a salary basis requirement, like lawyers, doctors, and teachers. Our education law folks have reminded me that the LEARNS Act carries with it some. If the LEARNS Act applies, it carries with it some compensation requirements, and so that's where I would defer to Chris Heller and Kai Eddings and our education law team for that. But it doesn't implement. Point of that bullet point there is there's no new salary basis requirements for exemptions where it didn't exist before. The other one is, you might have heard of, is certain IT or computer employees have an hourly rate requirement as opposed to a salary basis requirement. And that's not changing. The duties test for the exemptions aren't changing. So if, again, it's important, a reminder there that regardless of what your salary or the salary of an employee is, if they don't meet the corresponding duties test for the exemption, they're not exempt, they're misclassified. So it's important whether they are an administrator, a supervisor, executive, or a professional, or a highly compensated employee. It's much easier for a highly compensated employee. They just have to have one exempt duty, but they still have to have one exempt duty. So it's important that you make sure that not only it's a good time here to maybe go back, and I've done that with some clients where, in the course of looking at our salary thresholds, also a good time to kind of audit and review to make sure that the folks that we classify as exempt still meet the duties test.
Yeah, if any of y'all who have heard Wayne and I talk at any seminar, there's always, and especially since COVID, I think the review of exempt people, not only their salary but their duties, because the technological advances we have made and the organizational changes that everybody had gone through have I guarantee you taken a whole bunch of people from exempt to non-exempt, because they used to supervise two people and now they don't. Well, and so it is imperative to get those job descriptions and go through them and look at them at least annually for compliance. And that's gonna, I always get on my soapbox. It's that job description, it helps you so much in an ADA situation, and is going to start ruling the day in whether you're going to get somebody exempt or not.
Yeah. Another question I've had, recently come up is about just a reminder that you might have employees that meet more than one of these criteria. Like they may be an exempt executive and an administrator, or they may be a highly compensated employee, but also meet the criteria to be an exempted executive or administrator. That's, there's no, if you're either exempt or you're not, you can be exempt under on several different categories. It doesn't legally change how you're treated or classified or how you're paid. And there's no, the one thing I'd say about that is the more, if we identify the exact exemption on a job description, I would list all that apply in the event that you were ever challenged or audited, or, we can have a fallback, if there's something that's changed, or there's something that's not, we can't prove necessarily with facts. With one exemption, if there's a backup listed, there might be kind of a fallback position there. So people can meet more than one of these categories at the same time. There's really no legal meaning to that, as long as they meet one. If you're exempt regardless of the category you fall in. The rules related to how overtime is calculated and paid for non-exempt employees have not changed. So that's important to know for the folks that you may reclassify to non-exempt, because they don't, they're not going to get bumped up to the salary threshold. The option there may be to reclassify them as non-exempt. If we do that, then the overtime rules and regular rate rules have not changed. And we'll talk some more detail about some compliance strategies for that as we go. The 10% rule, what I call a 10% rule, hasn't changed. Question earlier about, highly compensated employees. My understanding is that the 10% rule applies to them as well, and would after July 1 and January 1, where up to 10% of their salary can be paid via non-discretionary bonus or commissions that are paid annually or more frequently. Now, that math gets complicated when we've got a current threshold, a new threshold in July 1, and a third different threshold in January 1. The 10%, as you know, I mean, it's easy math, is a little bit of a moving target. So that's kind of an oddball question. We'll talk about more at the end. But basically just, again, this is one way where, there's another provision in the rules for catch up, where what I call catch up, where if you get to the end of the year and you realize, you haven't paid the full amount of the salary, you can, because perhaps you have this you're paying part of it with a non-discretionary bonus or commissions. and through the formula or through sales or whatever, you don't fully make up the difference in the bonus or commissions, then you can just do a flat one-time payment as a catch-up as well. Again, that's limited, self-limiting, so to speak, with because 90% of the salary or the amount has to be paid on a salary basis.
Yeah, and I think one thing that some people might want to consider is that, because of the complexities in the overtime calculation, a lot of people have spent a significant amount of effort making bonuses discretionary so that they're not considered in a regular rate. That this may give an impetus to change discretionary bonuses to non-discretionary so that they can be used to make that 10% up. That's just another strategy we'll kind of touch on. Question about outside sales position. That's not, and we're not, this doesn't affect the way we analyze an outside salesperson.
Yeah, I should have included some good legal jargon in bullet point 2 there, where this, including but not limited to lawyers, doctors, teachers. There's a bunch, right? Outside sales, James, is a good one. I've got a lot of logistics clients, drivers that are exempt under the Federal Motor Carrier Act. This has nothing to do with any of that, right? This is the white collar exemptions and the salary basis test for certain of those exemptions. So, Motor Carrier Act, DOT drivers, outside sales. There's others that I'm drawing a blank on. I believe it's in 13B B1 of the statute.
Yeah, commission inside sales.
Retail inside, commission sales. So there's a bunch of them, but this is strictly limited to the salary basis for the white collar, the white collar employees. The easiest way to think of that is those employees already would have been on a salary basis requirement. This just increases that threshold. So if they weren't on a salary basis requirement before, there is no new salary basis requirement for different categories of exemptions.
Yeah, for 95%, 98% of the employees of everybody who's on this call, we're talking about managers and administrative people.
And a few professionals mixed in.
Yeah,
I had some of those questions, but
you're right, Mike. That's why I gave that 2%. Those are
there you go.
There's a few of those, but most of who we're talking about are the people we're going to slot in as executives, the managers or the clerical non-manual labor administrative exemption, exercising discretion and independent judgment as to matters of significance.
You ready for the next slide?
Yeah.
So what should you be doing now? In light of all this, it's, we're getting to the nitty gritty here. We're just a few weeks before the implementation date. So if you've probably already started this, but if you haven't now, maybe you're a smaller employer, smaller company. So now's a good time to do it. Just look at your exempt staff that are, like I said, if they're already over the threshold for either July 1 or certainly January 1, then, again, might review the duties test and kind of do your own, make sure we're all still in good order on the exemption. But for those that are currently paid a salary less than the scheduled new amounts, that's where we're going to have decisions to make. And like Mike said, if you're in a bigger market, this is not, this doesn't mean anything to you. If you're from Morrilton, Arkansas, like I am, this is significant, right? You're making some serious business decisions based on these changes. So who's paid less than the new amount? And then what are we going to do with those people, right? Are we going to, and that's the next slide. What are we going to do? So Mike, any thoughts on that before we advance? Yeah.
Yeah. I think some of the issues I've been dealing with and talking to people are people who have a significant non-discretionary bonus / commission a lot of retail store managers have a significant portion of their compensation plan is loaded into a non-discretionary bonus / commission. And so the question then is going to be, do we want to change the mix there where we guarantee them more in a salary to get them to the 90% threshold, yet still hold back enough of that non-discretionary bonus that is a motivator to get them to perform. And everybody's going to have to answer that question based upon their own thoughts. As this threshold, as this slide talks about, we have at least 4 different options of how we would do that. And I think any of them are in play. I think right now it's relatively simple for people who have made the 35 plus threshold to take them to a 90% of the 43 and change threshold, right? It's not a huge jump. And my guess is there's a whole bunch of people that are close or right on the edge.
Yeah.
Well,
So yeah, I mean, like I said, that's those first 2 bullet points there are kind of one and the same in a sense, where you're adjusting, you're saying, look, we're going to try to maintain the exemption, and we're going to do it through just getting the salary over the line. And so you can either just flat rate, again, if somebody's making, if they're already at 50,000, 51, 52, looking forward to that January threshold, then that's an easy, they're already exempt for the July one. That might be an easy one, but to Mike's point about, even easier would be if you could go to this 90%. To clarify for this, when we talk about this 90% threshold, that's kind of the corollary of what we saw on 2 slides ago about 10%. So that's kind of the corollary of this. 10% can be commissions or non-discretionary bonuses. 90% has to be, in the salary basis.
and so I think we answered, we talked about this question a week or so ago. How do we do this? Because it's a middle of the year deal and it says for annually. And we're only going to have 6 months at this level. So how do we do that? And our collective judgment, and I think it's correct, is that what you ought to do is start July 1 and half everything. And if I pay 21, whatever it is, half of 43,888 between July 1 and December 31, then I've done it. Okay. I have met the test for that, because otherwise we got to go back and think about what we paid during the first half of the year. I can imagine a circumstance where somebody had a non-discretionary bonus that was paid in the first half of the year, but wouldn't get paid in the second half of the year. That might get us over the hump, but we start getting into complicated head spinning mathematics there that might not be worth it. If somebody's got that situation where they think they want to go back and capture something from the first 6 months of the year, I'd like to hear about it so we can discuss it. I just hadn't been able to figure out that situation.
Yeah, that's what I was going to say. If you really want to make your head hurt, think about, you'd probably have to also do a separate calculation for the first half of 2024 to make sure you've met, that whatever you've paid in bonuses or commissions meets the 90-10 rule based on the first half of 2024. And so there might be two different amounts there that you'd have to account for and make sure that we're all paid up to be in compliance for 2024. So yeah, very, very interesting question. Let's Jasmine, let's go to the option slide, and I believe it's one and forward from there. There we go.
Next one,
Yeah.
yeah, there we go.
So yeah, I say be mindful of catch up rule there, just because there is a catch up rule where what happens if I get to the end of the year and my employee did not make enough of the bonus or commissions to make up the full 10%, assuming that you're using that full slack. Well, the law allows you to just do a payment of whatever the difference is to catch them up. So and in this weird year where we've got two different thresholds in 24, there might be some complicated math there, but we can certainly help try to figure it out.
Yeah. So let's just run this out. Let's use some round numbers. Between July 1 and December 31, they got to make 22 grand. And so you can set their salary at 19,800 and 2,200 of that. Then you can add 2,200 as a non-discretionary bonus. And then let's just say they only make enough, their store only performs well enough for them to get $1,700 in non-discretionary bonus. So you're 500 from the finish line. I promise you would rather pay that 500 than go back to try and figure out how to treat them as non-exempt, because under this scenario, you hadn't been keeping track of their hours. So the catch-up rule is, oops, they don't make it, you got to make the payment, because you really don't have any other choice at that point.
Last thing on that, commissions are pretty straightforward. I've heard some people, tell me, well, Wayne, all bonuses are discretionary. Like, I don't have to give a bonus. Well, that's illegal. The non-discretionary versus discretionary there is a legal term of art that means, like, is it formulaic? Basically, is how I describe it to people. Is there a set criteria or formula? Versus you get to the end of the year, you had a good year. Hey, we're going to give everybody an extra, couple $100 or something just on a, versus if we meet these thresholds as a business, here's the corresponding amount of bonus that the managers get, that the executives get, et cetera. And so that's what the non-discretionary part of that means, is it's based on some formula, criteria, or set amount that's really not subject to being it's subject to being taken away by the employer, but the amount of it is formulaic, is what non-discretionary means there.
If you announce to your employees, if you do this, or your business unit does this, or the company does this, you get X, Y, and Z, then it's a non-discretionary bonus. That's the, and a whole bunch of y'all, I suspect, have been through some audit / lawsuit where the allegation is there were non-discretionary bonuses that didn't get included in the overtime calculation. I can't tell you how many I've handled the last 5 years. Fewer now. I won't get into that anymore. But so the next ideas are, if we don't think that we can meet the salary criteria, and then we have the opportunity to reclassify them as non-exempt. That's the next option open to us. And some people that I'm talking to are considering doing this, even though they could probably make them exempt for the remainder of 24, because they know that they're not going to hit the 25 number, which is this really significant increase. We're going to talk in a few minutes about the litigation that's pending, and how it's going to affect y'all's decision making about this. But let's talk about those options and what the ramifications of them are. Then we'll talk about what we might predict in the litigation, so that you can go from there.
Might talk about that last bullet point. I think that's an interesting idea about basically kind of restructuring the position or the duties such that, you can, uh, take a current, somebody that's a job classification that's currently exempt under current rules and say, maybe just do away with that and
yeah,
reassign some of the exempt duties to some folks that are over the threshold, and then, reassign other duties to, to non-exempt folks.
yeah. So I'll give a little bit of a real life example. A lawsuit that I handled a couple of years ago was talking about whether a purchasing manager was exempt or not. And so let's just say you have a purchasing department and you treat those four purchasing managers as exempt because they all have discretion and independent judgment as to matters of significance. They have a significant amount of authority to negotiate price on items and so forth. And let's just say that they all make somewhere in the $38,000 a year range. And so currently they meet that threshold. So if let's just say that theoretically we have four of those purchasing managers, and what we might decide to do is take two of those managers and say those are purchasing manager one, and they retain all of those exempt duties, and we're going to pay them 48,000 or 55,000 or whatever. But then we're going to have two others that we're going to make as non-exempt purchasing managers too, and they're going to retain their current salary, which takes them below, but and so we're going to make them non-exempt, but we're going to keep these other two because they've been here the longest, they've got the most experience, and we may think it's worth raising their salary to a level that will get them in the exemption and keep them in the exemption. There
Barry's
are,
got a good question in the chat. First of all, thanks for tuning in, Barry. Haven't seen you in a while, but so to answer the question that Barry posed, if not everyone can see it, is he's like, so if the salary is 90% of the threshold amount, but the employee does not hit the non-discretionary bonus, are you in compliance? The technical answer to that, if that's all that happens, is no, you're not. That's why I specifically noted there, be mindful of the catch-up rule. If the bonus doesn't hit the full difference, it doesn't have to be 10%. It might be, you might do 95% salary, 5% bonus. So whatever it is, if they don't hit the 5%, the 10%, whatever your slack is in the full amount of the salary in bonus or commissions, that's where the catch-up rule comes in. You have to pay the catch-up to make sure that they get the full amount of salary of the threshold, or else, as Mike said, you're opening up a house of horrors of they hadn't been exempt the whole time. I mean, it's like a retroactive effect where they've never been exempt if you don't make sure that you hit the catch up in the event that they don't make enough in bonus or commissions to get to the 100%.
yeah, that's why I said the catch up is just you got to pay.
Yeah, and
No,
and so that's why you start getting at the end of the year, whatever your fiscal year is, or whatever the time period is, and start do that math to see if the bonuses or commissions are gonna, like I said, it doesn't have to be 10%. That's the maximum it can be. It can be, you may have 95% salary, like I said, 5% bonus or commissions. You just got to make sure whatever that number is, that the bonuses and commissions make it up. If it doesn't, that's why I put that on the slide. Be mindful of the catch up rule. You've got to come out of pocket and just pay the catch up to get it to 100.
yeah, and if you look historically at your payments of the non-discretionary bonuses, then you can figure out about where the sweet spot is most times to set to make sure that there's enough there to hit the 10%. For the remainder of 24, it's basically $2,200 is where it's got to be set.
All right. Anything else on that, Mike, before we advance?
I think, yeah, so I think that the next slide is to talk about the ramifications of the last two options, changing people to non-exempt.
Yes.
And yeah, so my guess is that most of y'all have been through the process of changing somebody from exempt to non-exempt because you were probably caught where you had misclassed them as exempt, and either through an audit by the DOL, a lawsuit by one of the plaintiff's lawyers, or talking to me or Wayne or somebody else, you went, oops, I think I probably need to go back and reclass them.
Yeah.
And so it's always a struggle. And let's start by this. As we always look at we always look at the risk level. And if you're talking about somebody, the question earlier about a part-time, I don't care how you classify them if they're part-time, because if they don't hit 40 hours, we don't care. The Department of Labor doesn't care. Nobody cares. There's not any overtime. And so if I got somebody who's working 2 hours of overtime a month, and I'm sitting here deciding whether I got to raise their salary or take them back to non-exempt, I'm not sure I'm going to poke that bear for that, because the risk is just minimal.
Yeah, that's a good point, Mike. And the other thing we've discussed with clients about is, okay, you're going to take somebody, from exempt to non-exempt. What do you got to pay them? And I think that's, still the law on that hasn't changed in terms of, as long as it's a, bona fide change, you can change their rate of pay. You can change the method of their pay. But to bullet point one there, when someone goes from exempt to non-exempt, it doesn't necessarily mean making them hourly paid. Most of the time, that's what happens because that's the most administratively feasible and an easy thing to do, and the easiest thing to administer for compliance purposes. But there absolutely are many employees that are salary paid but are classified as non-exempt. And how that works is you just track their, as you do for every non-exempt employee, you track their hours worked through some compliant method. And then if they've worked over, 40 hours a week, you go through a calculation of their salary to figure out what their regular rate of pay is. And then they get overtime premiums over and above their salary for weeks in which they work overtime. You can't cook in overtime into a salary, people. That's kind of the main trick that people try to use for that. You can't pre-cook in overtime and say, well, we're going to pay them an X salary that includes time and a half, and for assuming they work 50 hours a week and it's 10 hours at time and a half, and so that comes, so you do that math and here's the salary for that. That's not a legal compliant method. You would have to calculate the overtime due on a work week by work week basis and add the premiums due to the salary after the fact. You can't cook those premiums in to a salary for a non-exempt employee on the front end. That's the main kind of mistake I would say that people make on trying to pay someone a salary that's non-exempt. But you don't have to pay them hourly. Like I said, you don't have to pay them a certain amount. If, like Mike said, you might do some reverse engineering on, okay, well, we know this person's going to work on average 42 and a half, 45 hours a week. What do we want the compensation for that to be? And you can reverse engineer that. But then it needs to be a bona fide rate going forward for that person, or model or salary or wage rate, hourly rate, whatever the case may be. But you can change it if they were, say, $40,000 employee currently, and we didn't want to, their position didn't justify a bump. So we wanted to leave them, we're going to reclassify them as non-exempt. You can, bump their pay up, bump their pay down, take them to hourly, leave them on. There's all kinds of options available to you as long as it's done with a bona fide change. What I mean by that is that it's a prospective change where you make the change today or on July 1 and it's effective going forward.
Yeah, yeah, and you also got the opportunity to do a fluctuating work week on salaried non-exempt that may be able to save you a little money on the overtime premium that you pay. The big problem, the elephant in the room, is that they're going to have to start keeping their time when you make them non-exempt, and that even if you keep them as salary, the morale issue with making somebody keep their time who's not used to it is significant, and we all know that. So there aren't any good ways to skin that cat, but without being non-compliant with the record keeping requirements.
Yeah, Barry asked again about, using fluctuating work week. If the employees, if they only fluctuate a couple hours a week, yes, that's what that's for. Frankly, it's what fluctuating work week is for when, there's some variance, in their time. People think, the regs characterize it almost as it has to be, these crazy variances, high and low. But I don't think that I don't think that it necessarily required. One thing I'd say, Barry, on fluctuating work week, where I see the most compliance headache is making sure that it's clearly communicated to the employee on the front end that their salary is intended to cover the straight time of all hours worked. You can't be clear enough on that. If you need to have an employee sign some kind of acknowledgement or separate policy for that, I would love it. I mean, you cannot be clear enough on, look, your salary, it's not for 40 hours. It's not for some 35 or arbitrary amount. Your salary is intended to cover all hours work and the straight time pay for all hours work. If they work overtime, as we know in those weeks, they're entitled to an additional halftime premium in the fluctuating work week formula, but it needs to be clearly communicated. Look, you're being paid on fluctuating work week model. Here's what that means. You're paid to say, you can't be clear enough on the front end, because that's where we see the most opportunity for, Department of Labor questions, plaintiff's lawyer questions, et cetera. So
yeah, I won't let a client of mine do a fluctuating work week unless they send out the standard statement we've developed that covers those things, and we can prove we got it to them. I do think I'm a big believer in using the fluctuating work week where two things happen. Number one, there's lots of fluctuation, and number two, the fluctuation goes under 40 often enough to justify it. If we're somebody that's between 40 and 42, then I wouldn't do it. It's not worth. You're not going to gain enough by it, and you take the risk of it. Somebody saying that really is not a justifiable use of it.
and the
Got another
alternative
question.
would be right. And the alternative to that is just you set the salary as covering a certain amount of hours.
Right.
And yeah.
So what if we make the first salary increase and decide not to implement the second increase and the duties didn't change? No, do I owe overtime for the last half of 24? No, you've been in compliance for 24, then you're changing them to non-exempt for 25, and you're back in compliance, just in a different way. But the timekeeping issues are significant because you've got people who you've treated as exempt. They've got their company email on their phone. They're used to answering questions when they're at home. That, all of those hallmarks of somebody who's exempt, and you take them to non-exempt, then we got timekeeping issues. We got people who are wanting to act the same way, whose people that report to them are used to being able to get a hold of them when they're not there. And that's a timekeeping issue. And so we've got to develop policies and procedures for them the way we do other people who have been non-exempt. And that's turning off their phone email. That's not really a good solution because they're just going to text with people. And so we have to set up a policy that says if you spend more than a diminished amount of time texting or emailing while you're sitting at home at night, then you have to record that as time worked. And we provide them some method to do that. And then what we need to do is for a period of time after that, then we need to monitor that and audit it and randomly look at somebody's email and show, okay, how many emails did they send and receive after work, after they went home? And do we need to account for some additional work time because we've taken them back to non-exempt?
There's good, to borrow a phrase, there's an app for that. A lot of instances where, the technology is improved on, mobile timekeeping for, remote workers, mobile workers, transient workers. And so, you might just have to get creative with timekeeping options, and using the technology to your benefit for that. Monitoring whether it's screen time or, like Mike said, looking at timestamps on emails and different things of that nature to try to ascertain, any trying to capture all hours worked, to make sure we've included them all and paid for them all. So, yeah, I mean, like I said, you would have to go through, make sure overtime was paid, obviously based on time and a half, the regular rate. For folks that were newly classified as non-exempt, that would be a change. And then Mike's alluded to this, the morale, employee relations piece of it is not to be ignored, because it's a stigma deal. People are going to, I'm being demoted, or, you don't think I'm worth enough to make the minimum salary threshold as an exempt supervisor. You just got to be prepared for all those questions. And that's where the soft skills of an HR professional that I don't have as much, come into play on how you're going to communicate that, how you're going to roll it out, to sell it to people that, this is, to comply with the law. It's, a lot of times, if you're reclassifying the non-exempt, it frankly may mean more opportunities for overtime for them, where they can make more than they're making now, perhaps, with overtime premiums, if that's the case. So yeah, it's the morale and this is real, and is not to be ignored if the plan is to reclassify folks as non-exempt.
And look, y'all are going to have to deal with whatever segment of your now exempt workforce that you moved to non-exempt. Now you're going to have to start dealing with all those off the clock issues that you've had to deal with before, where you got some people who are so diligent they're going to work off the clock a whole lot, and you got to make sure that you don't allow that consciously. I mean, it's going to happen sometimes. You can't help it, but as long as you put policy practices in place and audit it, compliance, you're fine. And then you're going to have other people who are going to try and take advantage of it, and they're going to claim, I was on the phone for an hour and a half last night, right? And so I'm putting that down, and that's as y'all have heard us say a couple of times, that's a disciplinary issue, not a pay issue. They put the time down. They may be lying about it, but that's when you just pay them and then fire them for lying if you catch them. But that's the compliance part that's just going to make everybody work harder for a while to make sure that the transition from not keeping time to keeping time happens in a better way. We got a question about timekeeping software, and my guess is that there's a whole bunch of y'all that do it a whole bunch of different ways, And there's just lots of timekeeping software out there that can handle this issue for you.
Yeah, installing it on company-owned property, I have no problem with that. I would think that full disclosure and transparency with the employee, I wouldn't try to necessarily, you know, hide it from the employees. I mean, I don't think there's any major privacy issue if it's company-owned property, but I think it would, making sure the employees are educated about what it is and what it does and how to use it, because if you've been through a DOL audit, this, but one of the things they're going to harp on is if employees, you can require employees to cooperate with you in keeping up with their time. Ultimately, DOL auditors love to say it, the obligation's on you to make sure that it's accurate, that the time record's accurate and correct. So if you've got to put timekeeping software on company property to track it, if that's what you feel you need to do to comply with that requirement that is on you as the employer, then I have no problem with that. I think, like I said, the best case scenario, especially with folks that were formerly exempt, that might have been used to working routinely off the clock without any thought of it, they need to be re-educated a little bit on expectations and work, work times and how work is recorded off the clock. And there might be some adjustment to expectations about, availability off the clock when someone's gone. And that's be part of the compliance plan as well. Our last bullet point here on this, back to our old friend, the non-discretionary bonus. As Mike said, that is a booger for non-exempt employees. And you just got to have a good plan on how to, basically what happens in that scenario is you say you pay someone $15 an hour and they've got this non-discretionary bonus out here of a certain amount. What the law requires you to do is that employee really didn't make $15 an hour. They made $15 an hour plus the prorated hourly portion of that bonus, right? Because the bonus is non-discretionary, is part of their income. So what you have to do is recalculate the regular rate to include that non-discretionary bonus. How you do that can get eye-crossingly difficult because oftentimes the bonus is not attributed to a clean work week or hourly, hourly equivalent. So there's a reg on that where that says basically that the employers have to just come up with a bona fide, reasonable estimate to attribute the bonus to of time, whether it's a month, a calendar year, a pay period, a work week. Oftentimes it's not super clean on that, but if you just kind of come up with some reasonable way to prorate the bonus overlaid with a period of time to come up with a prorated amount of that bonus to add to the regular rate.
And so the a couple of things. Number one, I've had so many times where I've had a client who had a payroll company who they said, we need you to make it where the payroll automatically calculates the overtime on the bonus. And the payroll company said, we don't know what you're talking about. We can't do that. Based upon my conversations with other clients, I would be switching payroll companies if that was an issue that I had going, because there are those that do. What Wayne was talking about, I was talking about with one of y'all 30 minutes before we started this, and where the earned period of the period in which the bonus is earned has several weeks, work weeks, whole work weeks, and then parts of one or two others. What Wayne was talking about, the reg that says a reasonable way of doing it, I think what a reasonable thing would be is that if it's attributable to a work week, a partial work week, then we're going to attribute to that work week if it's 4 days or more of that work week, but not if it's 3 days or fewer. That way we can attribute it to that work week, but then it doesn't get double counted the next time. My head's starting to spin as I say that, but that's how we do it. So we figure out a uniform way to attribute it across partial work weeks, because that's always going to happen when we have a monthly or a quarterly bonus. That's just the way it's going to work. So that's an easy way we can do. We're almost out of time,
Yeah,
so I
let's go
want
to
to
the
talk
last slide right
briefly.
quick and
I
talk
want to
about
talk
these last couple things.
the litigation. So the Plano Chamber of Commerce and about 8 million other organizations have filed suit in Texas trying to get the same judge to enjoin these changes. So far, nothing has happened but the complaint. There's been no motion for a preliminary injunction. There's not been an answer from the Department of Labor. Uh, One of two things is going to happen. They're going to wait till the week before so that they can hurry things up and keep the Department of Labor off its toes to get the injunction, or what may happen is that the injunction may not happen with this change, but it may happen with the 2025 change, because that one is a lot bigger jump. And so there's a lot better argument that it's an unreasonable increase.
Yeah. Yeah. So we're too late. I mean, what's today? June the 4th, June the 5th, June the 5th. I mean, we're less than well under 30 days from this going into effect. I'm not saying the judge they couldn't file some motion today for a preliminary injunction that would get ruled on before July 1, but that's extremely unlikely at this point that there's going to be any relief from this before July 1 at least. So yeah.
Hate to say it, but I think we got to plan on compliance for July 1, and then kick the January 1 can down the road until we see what happens.
Some oddball things, not necessarily things that we're seeing, but we've kind of anticipate we might see, or we want people to think about. Tim Orlando asked a question a minute ago. He'll amen us on this. You start kind of doing these odd changes to people's salaries within your structure, and you start giving people kind of bumps for, just for out of the blue, out of the ordinary, for purposes of compliance with this law. You got to be careful to make sure that you're mindful of things like the Equal Pay Act and Title VII and any affirmative action obligations you have, to make sure that those changes are done consistently and in a way comply with the discrimination law, such that we don't, make one change to comply with FLSA, but then run afoul, perhaps unwittingly, of another statute or issue, to make sure that, you just want to make sure that your pay model is taken with everything into consideration and the broad big picture view, with all the different considerations that you have, legal compliance, not just FLSA, but others as well.
So,
Another
so
kind of
let's
odd. Go ahead.
so let's say you got a union, and you have a bargaining unit, and then you have a group of supervisors who are not within the bargaining unit. If you make the change and take some of these people back to non-exempt status, they may go in the bargaining unit.
Yeah.
Now, there could be some strategies there if you
Yeah.
have some, but if you have some real loyal people. But my guess is that the people who are going to get stuck back in a non-exempt position are not going to be the happiest with the company, like what we've been talking about, the morale issue. So you may be hitting the double knot thing of, number one, I'm making somebody unhappy, and number two, what the change I'm making is putting them back in the bargaining unit, and so then I got more problems.
Exactly right. Yeah. Like it's just those labor law issues are complicated. If you're organized, that. And so I would just implore you to, seek good labor counsel on that, of the effect of any reclassification or significant changes of job duties, for sure. Yeah, those are the main, those are kind of some of the big picture things that Mike and I are seeing. We're kind of running up on our time here. And so appreciate the good questions, people chiming in. Jasmine's going to put up a couple more slides, and I think with our QR codes there for our LinkedIn page and etc. Most of you on here know how to find us. So reach out if this has triggered any other questions in your mind. If we can help, we certainly will. Just stay tuned. We're going to try to keep abreast of the dynamic nature of this, changes they happen, and roll those out. And so appreciate everyone tuning in. The good questions.
Yeah.
Mike,
Hey,
any closing thoughts?
Jasmine, will you send everybody the slides?
Send them the
And
slides. That's what I
then
was gonna say.
y'all just keep an eye out for the news blast. If a TRO motion is filed, we'll get something out on that. And obviously if an injunction is issued, we'll have something out on that as well. I'm going to do some reaching out to the state chamber and see if we can get some, we'll get some inside information from some of those folks, if we can.
Great. Thanks, everybody.
Thank y'all. Thank y'all very much. Y'all know how to get a hold of us.
Appreciate you, Broderick. Thanks for the comment. Yeah, we appreciate y'all.
All right. Y'all have a great afternoon.